Cheese.
Hi, Conversations with Keith. It's turned chilly, so I've got my hot tea, and this is, you talk about an old fundraiser. David Bay allowed us to sell these on girls basketball team in the mid-90s. And so I found it in the cabinet, and it's a nice little thermos to keep my hot tea, but it's cold. But we're still continuing with the political discussions leading up to November 6th. We have Stacey Sanning.
Hello.
Running for Pendleton County Attorney, and we're going to talk to her a little bit about what the county attorney holds. Who is Stacey Sanning? Give you an opportunity right off the bat, like we've done with all of these, to introduce yourself to the viewers.
Okay. Feels weird because I'm talking to a camera, but I know you all are watching, hopefully. My name is Stacey Sanning. I am 48 years old. I've lived here in Pendleton County since 1999 with my husband, Matt Sanning. We have 3 kids. Oldest is 23, 18, and then I got a 13-year-old. The 23 and 18-year-old go to Northern Kentucky University, and the 13-year-old is a student at Sharp Middle School. They've all gone to Pendleton County Public Schools. So I have a law office in Butler. I've been there about a year. But before that, we had our office in Falmouth since 2010, and then we also have an office in Augusta. My husband and I are partners. We're both lawyers. We're lawyers and married 23 years. I don't know how we've been able to do that, but that's something that it does happen a lot.
What do you mean, being
lawyers marrying each
Gotcha,
other?
yeah.
So it is kind of common, although Matt and I did not go to law school at this. Everyone assumes that we met in law school, but we did not go to law school at the same time.
When did you meet?
We actually met waitressing. I was a waitress, he was a waiter,
Okay.
because I had to work
Yeah.
when I was in school, even in law school, to make a living. So I got a job working at a country club in Northern Kentucky as a waitress to make money so I could live. And he was working there.
And I don't want to delve off of this side, but that seems like a lost thing that you have to do as a college student is work. It seems like anymore.
Not with my kids.
Yeah,
They're all working.
Yeah.
I know. I told them, my daughter, like me, I earned a full tuition scholarship.
Mm-hmm.
So all I had to do was worry about living. And my daughter's 18. She just graduated from Pendleton and got a full tuition scholarship. She was one of the valedictorians last year.
Mm-hmm.
There were 10. Don't let me start here. But there were 10, and she's got full tuition, and she's living at home and commuting. And I said, Emma, I hope you get a job because I'm not giving you any. I appreciate that I don't have to pay your tuition, but if you want money, you can eat here for free. I'm not charging her rent, but so she's working. They work.
And that's good. I mean, I think that's a very good thing that they need to learn to do and
Absolutely.
Build in that work ethic and build a resume to show that their future employers they're willing. Not able, willing to work, which is a big thing anymore. As we've said here and had numerous discussions with leaders who've talked about local business leaders, their biggest thing is they can't get people who are willing to work.
Right. I think one of the main problems with kids these days is, it's great that we have so many kids going to college. That's wonderful. But college, like law school, does not prepare you for life. Mm-hmm. It teaches you about your subject, but it's not the real world. And to be successful in life, you have to learn how to coexist with people, how to work with people, how to get along, how to be productive. And those are things that you have to learn on the job. They cannot be taught.
Yeah. Well, I had a new teacher. We did lunch duty together. And this was back before athletic director when I was still teaching. Actually, this was a long time ago because it was before I was doing alternative school. It was close to 20 years ago. And she was first year out, and it was about a month in, and we're standing there, and I said, so did everything you learned in class prepare you for being a teacher? And she's like, oh gosh, no. What I do on a daily basis, I didn't hardly learn anything. I'm like, yeah, that's everybody. Don't feel like you're abnormal in that regard. It doesn't prepare you until you get out there and you start doing it.
But my mom and my stepfather were teachers, and then went on to be school administrators. So Lincoln County, that's where I grew up.
Oh, okay.
Stanford is the county seat.
Yeah, I know Lincoln
Near
County.
Danville.
Good friend of mine, Ed Cravens, who used to coach here, he's from Lincoln County. His dad still lives down there, yeah.
I didn't know that.
Yeah.
Small world.
Where did you go to law school?
Chase.
Chase, okay.
Northern Kentucky University. I got a full tuition scholarship.
Now, when you go to law school, do you major in specific areas, or do you have emphasis on specific areas like teachers would, or?
No, it is, I guess, similar to teachers, except that you're not required to have a specialty. It's very similar to undergrad in that there are certain classes, mostly it's 3 years. Mostly your first year.
Three very expensive years.
I wouldn't know, I got a full tuition.
Oh, that's true.
But Chase is very affordable, and don't get me started on Chase because I love my school, but because we could digress for a long time on that. But the first year you do basics, constitutional law, criminal law, domestic relations, civil procedure, criminal procedure. So the first year, you pretty much, everybody takes the same, but then after that, there are electives that you can take. And then, I guess in that sense, if you are interested in a particular area of the law, you can take those classes. But for the most part, most of the time, there are certain subjects that are on the bar exam, because when you graduate with your beautiful law degree and hang it up on the wall, you're not a lawyer. You just have a law degree. To become an attorney, you have to pass an exam, just like a doctor has to pass an exam. And so most students focus on take the classes that are going to be on the exam. That makes a lot of sense. And that's what I did. There's only one class that I did not take that was on the exam, and that was income tax law.
That sounds...
And I got lucky because there was not an income tax federal tax question on the bar exam, so I got lucky. There wasn't a state. I did take a state tax, so I know about that. That deals with the kinds of consequences of inheriting estates and how to help people with their estate planning so that they can leave their property with a minimum amount of. I did take that. And that sounds really exciting, right? Income tax is even worse than that, trust me. I tell people all the time, my husband is a bankruptcy attorney. That's what he does mostly. And I joke with my friends, they're attorneys all the time, the only thing that could be worse than being married to a bankruptcy lawyer would be being married to a tax lawyer. I got lucky that he didn't decide to do tax.
Hopefully that wasn't an 8 a.m. class that you just kind of like, the early morning classes sometimes can be challenging, and then you have an exciting subject like income tax.
Yeah, I didn't take income tax.
That would make. So what your practice? What do you specialize in? With you said your husband was bankruptcy. What do you practice?
He mostly does bankruptcies. So a little bit about specialization. In Kentucky, we are not allowed to specialize, and I think some of you probably know that because in the old days, before they changed the advertising rules, when you would see a lawyer advertising on TV, you would see that little thing flash on the bottom. Kentucky law does not authorize specialties, and you remember that?
No.
Okay.
I thought you.
They changed the advertising rules now, so they don't have to do that. So there are no specialties. So you just get licensed to be an attorney, and you're licensed to do whatever kind of law you want. So it's up to the individual attorney to choose areas that they feel competent in.
Oh, okay.
Because we do have a duty to be competent. So I will turn down a case if it's something that I feel like it's not in my area and I couldn't be. But so I haven't really chosen one.
Yeah.
But I've ended up being mostly domestic relations. And I think I did a good job at it.
Like domestic abuse cases and those kind of things?
Divorce, custody,
okay.
Child support, domestic violence, where there's civil domestic violence, so, EPOs, DBOs, things like that. But I also do a lot of probate, a lot of estate work.
What's probate?
When someone passes away, helping people deal with the estate of the person that's deceased, how to make sure that the person's debts are paid and the property goes to who it needs to go to, and that there's title to people that have inherited something have the proper title to the property they've inherited.
Okay.
So.
All right. And you said 2010 you've been doing that here in Pendleton County, is correct? Is that what
I'm trying to think. No, I've actually been in Pendleton County since 2008.
Okay.
I had a practice in 2002, 2003. I've kind of moved around a little bit. I was with Ben Harder in Butler. So I had an office, and actually the building I own now, it belonged to Ben Harder then.
Okay.
And he let me rent space from him, and then I took some time off to have a baby. Took about a year off. And then after that, my husband had an office in Augusta already, so I just practiced there for a little while. And then I opened my Falmouth office in 2008.
Okay.
And then I was in Falmouth from 2008 until 17, and then we bought the building in Butler. Where the 2010 may have come in is my husband and I were not partners until 2010.
Gotcha.
If I said that, that's probably why. But we did share an office together. It's just I thought we already had one partnership, and I wasn't sure I wanted to have two partnerships, but it's worked out okay. So I think if you're used to, are you married?
I am.
I think if you're used to managing a household together, and if you can stay together long enough in a marriage, you can handle business too. I was just worried that might affect our relationship. So
I'm very similar to you. Wife's a teacher, so same career. We get to go home and complain to each other what's going on during the school day and those kind of things. And of course now I'm retired. She retires. She has like 16 days. And then she retires. So we're looking forward to being retired together. Well, let's go ahead and start talking about county attorney.
Let's do that.
What roles do you see? What responsibilities do you see as fall in that realm of a county attorney? And then what qualifications, skills, experiences, whatever the best word is, to kind of fill those roles that as you see with a county attorney?
Okay. Well, Kentucky is very different than most other states when it comes to our prosecutorial system. Most other states, a prosecutor's job is just to be a prosecutor. And in Kentucky, we actually have, every county has two prosecutors, pretty much. The county attorney is the prosecutor for misdemeanors and traffic offenses. Also, the county attorney does have prosecutorial powers for some felony cases, and that can get a little complicated, so I'll avoid that. And the Commonwealth's attorney prosecutes felonies. But the thing that makes Kentucky different is, and the reason I talk about prosecuting is I believe that is the most important role that the county attorney probably serves, because I think the most essential function of government is protection. I mean, the main thing the government should do is protect its citizens. So in that case, I hate to refer to TV, but if you watch the first 30 seconds of Law and Order, you know what I'm talking about. The police obviously are part of that, but the police can only charge someone. To convict someone under our Constitution, they are entitled to a criminal process and a court process and have all these constitutional protections, and it's the lawyer's job, the prosecutor's job, to convict or to do whatever is just and fair. But the county attorney actually does a lot more than that. For example, there's a federal program for child support collection. So most of you probably know Mr. Dean because there's a federal subsidy and a state subsidy that allows the county attorneys in Kentucky to assist people with child support, and that's a very good program. So, and that's not criminal. Usually, that's just helping people who are owed money to go to court, because otherwise, sometimes people call me and they want my assistance, and I have to charge them, and I feel really bad if someone calls me and says, well, my children's, it's usually the father, but sometimes it's the mother, the other parent isn't paying, and I'm owed $10,000 and I don't have any money and I'm living in poverty. I don't want to charge that person money to go get their money. That's horrible. They're suffering. And the child support office does that for free. So that's another thing they do. They also assist people.
So that's kind of in your wheelhouse right there, that responsibility to the county attorney, because that's what you're doing on a daily basis.
Oh, well, the prosecutorial is in my wheelhouse too. You asked me what I tend to do, but if I had my way, I'd do all criminal defense cases.
Okay.
But the problem is most people can't afford me. Seriously.
For our criminal defense.
Yes, I mean, I get those calls, but again, I have 2 offices to run, and I have 2 secretaries to pay for, and plus my own family, so I can't do those for free. So most people get the public defender. But anyway, the county attorney also acts as the civil attorney for the county. So not only are you assisting the public with prosecuting criminals, collecting child support, they also assist the public with mental health issues. So if you have a family member you think is a danger to themselves because of their mental health, the county attorney assists with, involuntary commitments, Casey's Law, the kind of the same thing with drug addiction. If you have a family member that you feel has a substance abuse problem and they're endangering themselves under this new law, Casey's Law, the county attorney assists people with that, helping them get treatment. So there's a lot of things that the county attorney does, but the two main roles are prosecuting misdemeanors and traffic cases and the child support. The county attorney also acts as the civil attorney for the county. So, and that's important. It's just one that the public doesn't get to see a lot of. So the county attorney has to attend the fiscal court meetings. And it would be the same as if I represented you, Keith, I would be giving you advice. I would, I may have to draft legal documents for you depending on what your needs are. If anybody, if I was your attorney on retainer, if you wanted to sue somebody or anybody sued you, I would be representing you. That's what the county attorney does for the county. Gives legal advice to the county, drafts legal documents for the county, ordinances, whatever needs to be done, and represents the county if the county needs to get involved in litigation.
So this is a position that
Many
the
hats.
responsibility, many hats, and I mean wide variety, from prosecution to disability to advising the government leaders to drafting documents.
It is.
I
And
mean,
it requires somebody who has a vast knowledge of many different areas of law. So that's what's unique about Kentucky is that is a lot of hats.
Mm-hmm.
So for the most part, it needs to be somebody who's been an attorney for a while, because if you are an attorney like me, I said I mostly do domestic relations, but when I call myself a small town lawyer. I mean, it's probably a little derogatory, but that's what I think of myself. I am not a big city lawyer. I've always been I've always practiced in rural Kentucky, which is very similar to where I grew up. I kind of think of myself as an Abraham Lincoln of sorts. He had his office in his home in Springfield, and people would come in and they would have all sorts of problems, and he would do his best to help them with them. And that's what I am. So I very rarely turn someone away just because I say I do domestic relations. If someone calls me and they have an issue, I advise them on it. It may not be a case that I ultimately take because it may be something specialized, but so you have to, as a practicing lawyer in a rural county, you have to learn a lot about a lot of different areas of law to help people with their problems, because people don't have the same problems. People are not cookie cutters.
Yeah.
I tell people all the time, sometimes they call me up and I don't know the answer. When you're in law school, they do try and teach you a lot of law, but it is impossible for an attorney to know everything. What they also teach you in law school is how to look up the law that you don't know.
Yeah.
So that's your job as an attorney. It's not just to have knowledge and experience, but it's also to look up the things that you don't know and research things. And that's what I do.
Gotcha.
I do that a lot.
You mentioned a couple things that I made a note on that I wanted to circle back to. You talked about the prosecutorial, which is probably a word I just made up. Aspect of it is not really felonies. That's the Commonwealth. Although you said that there's some area that you didn't want to delve into because it was kind of tricky. But you mostly mentioned traffic and misdemeanor. Traffic, of course, being, I'm assuming, DUI, don't have your license, don't have your register.
Traffic is everything from a speeding ticket up to driving on a suspended license or a DUI. Speeding ticket, obviously, fines. DUI or driving on a suspended license could carry automatic jail time, depending on how many prior DUIs you have. So traffic encompasses a lot of things.
Gotcha. What about misdemeanors? What are some of the charges or some of the things that would occur that would be labeled a misdemeanor? Because we know that term, but I don't really know what is like burglary.
Okay,
is that
now
a
you're
misdemeanor?
testing me. It either comes from the Greek or the Latin. I believe it's Greek, and it literally means little crimes.
Okay.
And a misdemeanor is defined legally as anything that carries 1 year or less jail time.
Okay.
As a penalty. And the most common ones that you will see in district court, and misdemeanors, the county attorney practices in district court. That's another strange thing about our court system is ours is a little different than others. So those would all be in district court. The county attorney does not go to circuit court in a prosecutorial role unless they can act as an assistant to the Commonwealth's attorney if the Commonwealth asks.
And district court is Jay Delaney.
No, district court is Judge Custer, who is running unopposed.
Okay, and then circuit court is Jay Delaney.
Circuit court is Judge Delaney, and circuit court in criminal cases are all felonies.
Okay.
The circuit court does not have jurisdiction over misdemeanors. They have to be in district court. And so the county attorney does literally all the misdemeanors. And the most common ones you will see are assaults, where what we call minor assaults, the technical term is assault 4th degree, but an assault where there's no deadly weapon involved and where there's no serious physical injury would be a misdemeanor. Criminal mischief, that's what we call when somebody destroys your property, damages your property if the value of the property is under a certain amount. Bouncing checks, that's a big one, where the amount of the check is under $1,000. That's in district court. AIs.
Is it the individual check or total checks? Because I know
individual.
Well, I was going to say, we're typing those district courts up, and I see people 18 counts of bouncing checks.
Yes.
So each one has to be underneath 1,000.
Yes.
And it's still a misdemeanor. Okay. So they could have bounced a total of $7,000 dollars worth of checks, but over 18 checks, none of them raised above 1,000.
And
okay.
The maximum penalty they can get is a year. So if somebody, for example, to give your example, bounces 10 checks at a time, the maximum I can give them is a year on each one of those, and usually it's up to the judge whether to stack those or to allow you to serve them all at the same time. And judges never stack misdemeanors. It's not allowed. So the maximum, and that's frustrating, I know, for a lot of people. They see somebody and they have several bounce checks and they're like, why is that? That's why. But most people do not get jail time for bounce checks. In our jurisdiction, most of them get fines and pay restitution.
Okay. You mentioned Casey's Law, which intrigued me.
Yes, that's new.
Since it's new, let's talk about that. What is Casey's Law?
Well, it's named after a person who died of a drug overdose. And it's a law that's been passed in several states, not all the states. Kentucky has adopted it. And it allows a friend or family member who thinks that someone has a substance abuse problem and is a danger to themselves or others to actually force them to get treatment.
Okay.
So, mental health is a tricky area. We have rights in this country under the Constitution to choose our own fates and choose what we want to do. And it's very difficult outside of the criminal law to have a judge order someone to do something or order someone to go somewhere that they don't want to be, like a mental health institution or a substance abuse treatment center. Casey's Law allows a judge to do that.
So it's judge, not a jury?
Yes, it's a judge.
So you'd have two lawyers that would give their case of why they shouldn't go, why they should go.
What happens is the person that files the petition has to go to the county attorney. The county attorney helps them with the paperwork, but they have to make an arrangement for the person that they're filing against to go get an assessment with someone who is licensed to give a substance abuse assessment. Could be a medical doctor. It depends on what the substance is. You can do this for alcohol too. I say substances, but any kind of addiction where the person is a danger to their own health or maybe other people.
Because I think there's a lot of people in Pendleton County who feel like they're in that spot with
there are
a
a
loved
lot of
one.
people. There are. And, in the old days, what would happen before Casey's Law, people would call and we would just have to throw our hands up in the air and say, sorry, unless they have a mental illness, you cannot commit them against their will. I mean, you can't make somebody go to the doctor if they don't want to go. But with Casey's Law, the first step is they go to this evaluation. If the judge is convinced that you've put enough in the paperwork that the person needs to go, the judge will order them to go to this assessment, which is a small infliction on someone's liberty to force them to go. But the person who files has to pay for this too. So the only thing that the judge is doing is ordering a person to go see a doctor and talk, or a counselor and talk to them.
So if
that counselor then, I'm sorry.
If I brought charges on one of my loved ones or whatever like that, then I pay for the rehab and the treatment.
Yep.
Okay.
Yep.
I just wanted to clarify that.
That's hard, but yes, you have to pay for it. So the only consequences to them is that they have to go. But the first step is they go to this assessment, and the professional who makes the assessment is required to file a report with the court, which is confidential. Some members of the public can't get it, but to recommend whether or not they believe that person is a danger to themselves or others. Then the individual who supposedly has the problem has a right to hire their own expert if they want to, but there is a hearing that's held in front of the judge where...
Which judge? Kuster, Fryman?
This is in district court.
District court. And remind me which one.
It's Judge Custer.
Judge Custer.
He's running unopposed.
Okay.
Which I like Judge Custer. Judge Custer is a former prosecutor. He was county attorney in Harrison County for many years, and I enjoy practicing in front of him. He's on all the criminal cases I've had, I thought he was very fair. I
can say when I was at alternative school, that was where some of the cases of my students would end up. And I agree with your assessment. He was very fair, very hard. He would always crack me up when he would tell them, if you don't do this over the next 3 days, bring your toothbrush with you because you're going to go away for a little bit.
Judge Probus used to say that too.
Yeah.
We skipped over that when we talked about the county attorney does so many things, but that is also, the county attorney doesn't just prosecute misdemeanors, but the district court has the sole jurisdiction over juveniles. So if a juvenile does something that's a crime, that's called a public offense. The county attorney handles that. If the juvenile does something that is not a crime for an adult to do, but that a juvenile could be in trouble for, like skipping school, talking back, being beyond control, those are called status offenses, and those are also handled by the juvenile court. And then the county attorney also is involved with cases where the Cabinet for Families and Children removed children from parents or custodians because of neglect or abuse. And I am very involved in that. I represent people, many people, and a lot of times the children in those cases. So I've got my hand in all of these little pies. It's just that I'm not the prosecutor. I'm on the other end of it. So everything that we're talking about, I have been involved in.
Okay.
So in Casey's Law, what would happen is, because the county attorney assists the people who are seeking treatment, trying to get, I would be representing the person opposing the treatment. So I would be, either arguing against...
In your role now, but as county attorney...
That's my experience that I have right now, so I see it from the other side. But I've also had prosecutorial experience too. I spent 5 years as an assistant county attorney in Nicholas County, so I've had it from that side too. I see it from both sides.
Gotcha.
So.
And as a lawyer, you kind of have to see both sides because
you do.
You also, in your preparation, as I would see it, in your preparation, you have to try to figure out what the argument that the other side is going to make, and then you come up with your strategies to diffuse that argument.
Being an attorney is like playing chess.
Yes, yeah.
You have to think ahead, 2 moves ahead constantly, and be prepared for what the other, like you said, what the other side's going to do. The best defense is a good offense. The best offense is a good defense. And yes, the law is very much like that. You have to see all the different consequences and possibilities of everything.
Oh, I was sitting here thinking as you said that when I was girls varsity basketball coach, as we would make the drive over to wherever we were playing, in my mind I'm thinking, okay, this person gets in foul trouble, who am I going to sub in? They go to this defense. And so in my mind, I played out so many strategies in my head that if that strategy would occur in the game, I'd have already thought about 3-4 hours beforehand what my response was going to be. So you could make a quick decision, not because you were quick-witted at that moment, but you'd planned it out 3 or 4 hours beforehand.
That's an excellent analogy, because just like a basketball game, I didn't know you were a coach, by the way, but just like a basketball game, you can plan those things out, you can consider all the possibilities, but you also have to be able to think quickly on your feet, because you don't know what's going to happen during the game.
Yeah.
That's not foreseeable, and court is very much like that. You don't know. I tell all my clients before we have a jury trial, I have no idea what's going to happen. I mean, to a certain extent, unlike on TV, there aren't a lot of surprises in court, in that we pretty much know going in, because of the rules that we follow, what witnesses are going to be called, and in general what we think they're going to say. And usually they do say what we think they're going to say, but you never know.
Yeah.
And the test is in testimony. And I mean, I think the clearest example of that, without getting too political, is the Kavanaugh hearings that we saw recently. Everybody that saw that saw something different, I guess, depending on what your political point of view is. But I think until we actually heard Judge Kavanaugh and Dr. Ford testify, I think a lot of people changed their minds one way or the other after they heard them speak. And that just goes to show you how important the court system is, because you really don't know. It's very difficult to judge something until you actually get in court and you actually hear what people have to say and see the evidence. That's why I tell all my friends when they get upset about things like, I don't know, there was that trial in Florida a couple of years ago where
Trayvon Martin,
where the guy that shot that young black man was found not guilty, and a lot of people were upset about that. And I also did not understand it, but the problem is we weren't there.
Mm-hmm.
And we didn't hear the testimony, we just got the summary.
And there's been a lot of publicized trials anymore on those, starting back to the OJ trial and kind of since then, that kind of kicked off all of these more public and shown on court or shown on TV trials. Well, you mentioned a jury trial. Great segue for me into your ad.
Yeah.
You mentioned in your ad that it's been 8 years since there's been a jury trial.
It has.
And that the county attorney has been the prosecuting attorney. I'm assuming that's what you meant in that,
yes.
right?
Yeah.
Because I think there's been jury trials for the Commonwealth attorney has probably been. So you're looking at specifically like that. I wanted to give you an opportunity to kind of delve upon that and a little bit more.
Sure.
And just talk about that kind of issue.
Okay. Well, here's the problem. And, first of all, we elect our prosecutors, and that is something that's not unusual in Kentucky. That happens pretty much everywhere. We also elect our judges. As you pointed out, Judge Custer's running unopposed, but if he had been opposed, you would have had a choice. And the problem is that most people, thank goodness, most people, Keith here has never talked to me about law because he's never had to. Unfortunately, most of the time...
that's a good thing that I've never been in trouble.
Most of the time when people call me, it's not because something good is going on in their life. They're getting a divorce. They're in a custody case. They've been charged with something. Someone has passed away in their family. It's not a pleasant thing to have to call a lawyer. And fortunately, most people don't go to court because they don't have that issue. So you people that are voting on something that you really don't know a lot about. I mean, I'm sure a lot of people know Jeff. I'm sure a lot of people know me. But if you don't go to court and you don't see what's going on in court, you don't know. And in that case, voting becomes a popularity contest. You're voting on a name. You're voting on the person. And that's okay, but I wanted the public to know what I know, what I see. And it's really difficult to do that without getting personal and without sounding like I'm being critical of someone personally, because it's not personal. I like Jeff. I don't know very many people who don't like Jeff, even going door to door. I've met a few who've told me, but most people would agree he's a very nice man. Okay, so it's not a popularity contest. I wanted to somehow convey to the public why I'm running, which is I want to change the way things are going and things have been going and change the things that I'm seeing in court. And I thought the best way to do that without getting personal was to actually go do the research. So I went to the courthouse and I looked it up. It's public record. You guys could actually do it too if you wanted to spend about 15 hours at the courthouse. I wouldn't recommend it. Oh, it's not very entertaining, but that's what I did.
So what's the importance of there's not been a jury trial in 8 years? Because I'll be honest with you, I think you stopped by my dad's house on Lock Road, and he mentioned that to me, and he said, "Is that accurate?" And I'm like, well, I don't know if it's accurate or not.
It is accurate because I don't know what Jeff said to you in the interview that he's already done with you, but at the forum Thursday night, he admitted that it's accurate. He hasn't had a jury trial in 8 years. Why is that important?
And that's the question my dad and I got to. What you kind of just said, we don't know enough about the system and how things work to know if that's what we don't. You know what I'm saying?
Right.
Exactly what you said is what we said. We don't know what that means.
Okay. Well, here's my point. First of all, in his defense, according to the American Bar Association, the most recent figures I can find on this are from a survey done by the American Bar Association in 2012. It's a survey. I do not know whether they actually did research or whether they just. I think that what they probably did was just sent surveys to prosecutors all over the country and asked them how many of your cases are going to trial. And what they found was that in federal courts, 97% of criminal cases end up pleading guilty or getting dismissed, and in state courts, it's 94%. Okay. Now, that probably sounds terrible to you, but that's actually okay because our job as prosecutors is a little different than most attorneys. I'll use the example of Keith again.
That's fine.
If Keith retained me to represent him on some matter, I am his advocate, and it is my job to zealously, that's what our ethical code says, zealously represent him. That's a big word, zealous. So I have to argue his point as hard as I can and put his position forward as best as I can, regardless of whether I think it's a good position.
And if you don't do that, you can lose your law license.
If I don't do that, I am not being an ethical attorney. Okay? But a prosecutor has a different code. A prosecutor, so it's not your job as a prosecutor to nail everybody to the wall and prosecute everybody to the max. That's not your job. It actually says it's a prosecutor's job to do justice. Justice means fairness. Mm-hmm. All right? And so not everybody needs to go to jail for the maximum term. So, of course, most cases are plea bargained. That's normal. Okay? That's normal. But I guess what I'm trying to say with that is, I'm trying to do this without being critical. I think if you are prosecuting about 700 cases a year, in 2017, there were 533 traffic cases and 200 misdemeanors in Pendleton District Court. That's not counting the felonies, because you don't try felonies. So
gotcha. Mm-hmm.
But 700 cases, and in Kentucky, for traffic cases, we talked about speeding, you were entitled to a jury trial for speeding.
Now, is that at the request of the
defendant? Yeah, defendant can ask for it. Now, to be fair to him, most of the time you don't. But the last one that he tried in 2010 was a open container charge, which is a fine. So you were entitled to a jury trial. But I would think with over 700 cases a year, 94% of those would plead, but that means 6% you should be trying. And, I'm not saying that you can't go a long time without not trying a case. That doesn't, and that means that you're not doing your job. I'm just saying, what I'm saying is that what I'm seeing is a lot of cases getting set for trial, but none of them being tried. And he said at the forum the other night that people are afraid of him, and that's why. But I would just submit to you that I think as a prosecutor, you ought to be trying some cases. That's just how I feel about it. And I think the implication that you're not trying cases because people are afraid of you is an insult to prosecutors who are trying cases. That's basically saying, well, you're trying a lot of cases because defendants aren't afraid of you. That's not how it works. When I was assistant county attorney, and this is a funny story, I love funny stories. How I got to be assistant county attorney in Nicholas County could only happen in Kentucky. But for long story short, the long story is funny, but long story short, for 6 months, I was the acting county attorney for Nicholas County. The county attorney was AWOL. He wasn't around. And so I was running the office. And that was my first 6 months, by the way, as assistant.
Lovely. Just jump right into deep water.
And I tried 6 cases in that time. I lost 2 of them. I won 4. I did not set any of those trials. Those were all set by him because they get set several months ahead.
The previous county attorney. The one who was AWOL.
The one who was AWOL.
Yes, yeah.
Yeah. And that's not the current Nicholas County attorney, by the way. That is Dawn Letcher, and she's fantastic. And I worked for her for 4 of my 5 years. So, I mean, I don't know how to express it any better than that, except that Some prosecutors that I know like to brag about how they've never lost a case. And there's one that I know, Mr. Dean was saying that the other night, that the reason he hasn't had any trials since 2010 is because he won every jury trial he had before then, and people are afraid. And I also know one, I won't say his name, but he's currently a county attorney, and he brags that he never lost a case. And when I first started trying cases with him, that intimidated me. I was a little afraid, but then after I got to know him, I found out that I would show up for a jury trial and his assistant would be there, and I would win. So what he was doing was, when he knew he was going to lose, he sent his assistant out. So I don't think that it's about winning.
Uh-huh.
I think it's about doing the job of making people take consequences of their actions. If they deserve consequences, then sometimes you have to hold their feet to the fire. And my philosophy as a prosecutor was, and will be, I look at a case and I make an offer on a plea bargain. And that offer is going to be what I consider to be a fair offer. It might involve jail time, it might not involve jail time. It depends on the person. But that's going to be my offer. And I'm not going to change that offer unless I find out something in the course of the case that persuades me I was wrong about that being fair. Either the defense counsel is going to have to show something to me that I didn't know that convinces me that maybe I was wrong, or the defense counsel is going to have to show something to me that shows me I can't prove my case. But otherwise, that's going to be my offer. And if they don't want to plead guilty under that offer, we're going to have a trial. And I don't care if I win the trial or not, if that's the right offer. What I'm seeing is a lot of cases getting set for trial, and they're getting amended or dismissed right before the trial.
Are you seeing that's because of?
I don't know why. Because
okay.
I don't know why, because they don't put the plea. The plea bargaining's not on the record. So I don't know. They could have just gotten scared, like Mr. Dean said, and pled guilty right before trial because they were afraid to face the jury, and that does happen. I've actually tried cases as a defense lawyer where we started the trial and had a couple witnesses called and then took a break, and while we were in the middle of trial, my client changed their mind and decided to plead guilty. That does happen, but I don't know. To me, it seems like you would still at least have 1 or 2 trials in the last 8 years. And also what Mr. Dean didn't know was I did more than just write down when the last trial was. I know exactly how many trials he's had since he's been county attorney, so I really don't think that what he's saying holds water with me. He became county attorney in January 2007, and between 2007 and 2010, he had 4 jury trials, including the last one that was in my head. Mm-hmm. And of those jury trials, 2 of them were DUIs, 1 of them got fines, the other one got 7 days. The last one that he had was the open container, that was a fine. And 1 of them was a mistrial.
Mistrial for?
A mistrial. If there is an error during the trial and the judge considers that error is so bad that the jury can't possibly have a fair resolution, because sometimes once you hear something, you can't get that out of your head. The judge could say, don't pay attention to that, but if it's something so bad that the judge decides, even if I tell the jury to forget about that, I don't think they're going to forget about it. This person can't have a fair trial. We're going to declare a mistrial and have another one, and the jury goes home.
Do you know what from your research, do you know what that error was?
Yeah, I do. Mr. Dean referred to the defense attorney as a public defender in front of the jury, and the judge decided, for whatever, I wasn't there, that's what's written down, that Mr. Dean referred to the defense counsel as public defender, and the judge declared a mistrial. But that lady later pled guilty. Later on, there was a guilty plea on her. Okay. So that trial didn't go, but he did get a conviction eventually. So that's the kind of things that I'm seeing. I'm seeing things like in 2017 there were 24 assault cases that we talked about. Now remember, these are assaults where there's no deadly weapon and there's no serious injury. So we're talking
fist fight. We're
talking about bruises, scratches, black eyes, sometimes no injury at all. Yeah. And of those 24, let me see, I want to get this right. Yeah, 14 of those were dismissed just dismissed. No conviction, no record, no jail time, obviously. And the same thing the year before, there were 8 and 5 of them were dismissed. And that bothers me. I've talked to some other prosecutors that I know around here, and sometimes they do get dismissed, but you're supposed to talk to the victim and get permission before you dismiss the case. Mm-hmm. I don't know if that happened. I've had a couple of people tell me going door to door that they were not consulted. I don't know, but I think that's too many to dismiss because domestic violence is very close to me. I've had a personal loss where a friend of mine was murdered by her husband, and so I want to run an office where if we're going to do that, we're going to make sure that the victim is on board. And even then, I'm reluctant to dismiss a case if someone has done something where they've left bruises or marks or thrown things at somebody, because there's an enhancement. If somebody's convicted the first time, it's a lesser penalty, but if they get that conviction, even if they don't go to jail, and then they come back again and that's a second offense, it goes up to a felony. And I think that's important because one thing we know about domestic violence is people tend to repeat that if they don't get help and they don't get out of the relationship. It's going to happen again.
You had mentioned that as a defense lawyer, you have to zealously, and that word is the word that's used.
That's in the
yes,
code, zealous.
And it's a great word.
Yeah, we don't use it a lot anymore.
It does a good job really explaining how aggressive that you have to do it. But is there, on the flip side for prosecutor, I'm trying to make up a word again. Is
prosecutorial?
That's it. I knew there was a word, I just knew I wasn't saying it correctly. Is there a stance that they have to? I mean, for example, if you look at a case and you go, I can't win this. This is not, I don't have it here. Do you have a responsibility to not take it to trial, or can you still go take it to trial knowing that you don't think you can win?
Actually, there's a separate ethical code for that for prosecutors as well. We are not supposed to prosecute something if we think that there's no evidence or that we can't prove it.
Okay.
So, and, but to be honest with you, that doesn't happen a lot. I've been on both sides of the fence. I've been a criminal defense lawyer and I've been a prosecutor, and I know Mr. Dean has too. And it's much easier, even with the burden of beyond a reasonable doubt. It's much easier to be a prosecutor than it is a defense lawyer. Mm-hmm. Usually the police, I have to back up law enforcement for this. Usually law enforcement don't charge someone unless they have some good evidence.
Well, I know in talking to the candidates that we've had and in talking to the Falmouth Police Department, they feel comfortable, they know what gets a conviction in court. Mm-hmm. And so they're not going to bring charges until they're at that level or exceeding that level. They're not going to arrest a person on something and say, why waste all of our time and resources on this situation when we know it's not going to meet what's going to be convicted in court. And so just like you said, to give them the credit, they don't charge people until they know that they, or in their mind, they've reached that level that gets convictions.
Right. Well, 73 jury trials have been set since 2007. 73 have been set, and of those, only 4 have gone. That's what I told you. And one of those was a mistrial. Yeah. And he dismissed 15 of those, just completely dismissed them right before trial. I don't know why, but 15 out of 73, that's a lot. 18 of those people got fines, and 18 of those people got probated time. Only 9 people of those 73 actually got jail time.
I think 15 out of 75 would be 20%. So 15 out of 73
just
probably,
got dismissed.
Yeah, probably comes up to be 22, 23, 24%.
I don't know. That's pretty high. I don't know because, unfortunately when you're running against an incumbent, I don't have the advantage of sitting at the prosecutor's desk and talking to the police and knowing these things. And remember, these 20% we're talking about are just the cases set for jury trial, 73 cases. There's 700 cases every year that he deals with. But that does seem a lot to me. And the other thing that really bothered me was of those 73 trials, 23 of those were DUIs, which is a very common. I would say I was surprised that there were only 23 set for trial because when I was assistant, most of our cases that we tried were either DUIs or assaults, because DUIs very frequently carry mandatory jail time. So you can't offer probation. You're not supposed to offer probation if somebody, especially if it's what we call a per se, which is the legal limit. You all are familiar with that. When someone has a test and they test over the legal limit, that's called a per se prosecution, and the statutes actually say we can't dismiss it. There has to be we can offer something, but it has to stay a DUI. I can't change it to something else if they blow over that limit. And those 23 DUIs that were set for trial, 6 of them were amended to reckless or careless driving. And 3 of them were outright dismissed, and 2 of those one was a DUI second, and the other was a DUI third.
That was dismissed?
Dismissed, completely dismissed. I don't know why, but that's almost half. Almost half of the DUI set for trial. Now, on the other flip of it, the first case I ever tried as a prosecutor was a DUI, and I lost it. And I lost it before there was ever a trial, before we ever called a witness, because defense counsel made a motion at trial about the statutes. So to be fair, a good defense attorney isn't going to set a case for trial unless they think either the offer is unreasonable or they think they have a chance of winning. If I was representing Keith here, if Keith got in trouble, which is not going to happen, but if Keith got in trouble and I thought he was going to get convicted, I would put a lot of pressure on him in private to plead guilty, because usually a jury, if you're found guilty, usually the jury is going to give you more time than the offer.
Well, and having a conversation with a non county case. The defense lawyer told me this as we were talking about the case, said if it turns out that they actually have what the police say they have, he said, my recommendation to my client will be we never go to trial, because he'll get so much more in that. And that's what it turned out to be. And this is a federal case, so it's way removed from anything we're discussing here. But exactly what you said is, and he predicted that 8-9 months before it all came down, because he's trying to get, like you said, zealously representing and trying to get the best deal for his client.
Right. Defense lawyers have that obligation, but prosecutors don't. Prosecutors are supposed to do justice. So there was a prosecutor that I dealt with in Mason County, actually a Commonwealth's attorney, and she